It's because we've accepted a new theory about how our three branches of government should work, and in particular, how the judiciary should work. A whole lot of the responsibility in this body has been kicked to a bunch of alphabet soup bureaucracies. All the acronyms that people know about their government or don't know about their government are the places where most actual policy making, kind of in a way lawmaking, is happening right now. This is not what Schoolhouse Rock says. There's no verse of Schoolhouse Rock that says give a whole bunch of power to the alphabet soup agencies and let them decide what the governance decision should be for the people, because the people don't have any way to fire the bureaucrats. And so what we mostly do around this body is not pass laws. What we mostly do is decide to give permission to the secretary or the administrator of bureaucracy X, Y, or Z to make law-like regulations. That's mostly what we do here. We go home and we pretend we make laws. No, we don't. We write giant pieces of legislation, 1,200 pages, 1,500 pages long, that people haven't read, filled with all these terms that are undefined, and we say the secretary of such and such shall promulgate rules that do the rest of our dang jobs. The important thing is that when the Congress neuters itself and gives power to an unaccountable fourth branch of government, it means the people are cut out of the process. There's nobody in Nebraska, there's nobody in Minnesota or Delaware who elected the Deputy Assistant Administrator of Plant Quarantine at the USDA. And yet if the Deputy Assistant Administrator of Plant Quarantine does something to make Nebraskans' lives really difficult, which happens to farmers and ranchers in Nebraska, who do they protest to? Where do they go? How do they navigate the complexity and the thicket of all the lobbyists in this town to do executive agency lobbying? They can't. And so what happens is they don't have any ability to speak out and to fire people through an election. And so ultimately, when the Congress is neutered, when the administrative state grows, when there is this fourth branch of government, it makes it harder and harder for the concerns of citizens to be represented
Again,
and
if we get back to it, Ray
by
Carlson,
people
you're
that the
saying
people
we
know that
need
they have
to
power over.
look at it and examine it. You're not espousing any particular, any change other than go
the
to
law
the,
just
back
says
to
that
these
the Board
laws.
of Pharmacy must investigate how they
That's all.
investigate.
That's
and,
all. Yeah.
Right. I
That's
mean, they
what
would
you're
need to
asking
satisfy the judges to a certain extent. They
But
can't just say we went
exactly.
and looked.
Yeah, we took a look,
Yes.
saw
How
what
you
it
do
was,
that.
came back out. Yeah,
Right.
But again,
right.
that's what you're asking. And
The
people
law is
need to
very
be,
specific.
Yeah.
Now, do they have enough information that maybe the rules are being broke? There's, but those sorts of things really are secondary. Those are the merits of the case. We can't even get to that conversation with the judges until they decide whether or not I am worthy to bring this on behalf of the public. If you don't have standing, they don't care about what the rule says about the Board of Pharmacy. They don't care about the drug issue. I mean, to a certain extent of specifically. In general, if these judges in reading don't feel that I have standing, they won't read on. They'll just issue, you don't have standing, and they said it hasn't been given in 15 years. And that's the reason why they're not, what's the first thing they said on the
Is it so?
It hasn't been given for 15 years.
Yeah,
and surprisingly, the case that they cite, the Sheward case, it was a big case where public standing was given. Sheward involved an attack on the judicial system. And so they opened up public standing just enough for the judicial system to protect themselves and say that they can challenge the constitutionality of a legislative action, the legislative branch, the judicial. It was all centered around whether or not the judges are able to rule something unconstitutional or this or that. And it was a big threat to, so they opened the door 15 years ago or however, just enough for them to protect their kind of judicial system, and then they closed it again and haven't given it since. I give WFMJ a lot of credit for that, and it really is kind of like my signature video that I'll put up just to give a basic understanding of what this lawsuit is lawsuit is about.
Again,
it even says in there, I don't want to upset the Board of Pharmacy, and I appreciate that part more than. Because that is, what pharmacist would do that? Why would you want to agitate the agency that polices you? I don't mean to agitate them. I want to help them. They're under a lot of pressure with, their staffing levels and funding levels and everything that's been put on the shoulders of the Board of Pharmacy and their staff. And they're reacting to what input they get, and they have over the years. if no organization or association or no groups or individual pharmacists are bringing some of these things to their attention, they can't necessarily just make their own assumptions and just go out and start. Now, maybe you get to issues with the opiate and you might think that you would want to go in and take a look at some of the records. But for the most part, the Board of Pharmacy is just reacting to the type of information that they get, and they're understaffed and so...
Well, we can give them a lot of excuses for not, but they have an obligation too. That's why,
But I know Stephen Sherholt is doing the best job he can with what he has. I hate to throw this on his plate, but hopefully he understands that, certainly would do anything that I can do to help this along. We're not really asking for a big upset in the way the board is functioning. Just go in and take a look and let the people know whether or not they may have recourse to address this.
Which is all that you're asking, again, Ray Carlson, is to take a look. Correct?
That's all.
That's
all.
The filing
What happens after that? If they go in and find that compliance is running 5% on these various areas of then what they do and what the public expects should be done, it will be totally up to them. We will have done what we thought needed to be done, and that was just to ask the Board of Pharmacy to go in and assess. But again, right now, and I think what Marshall's challenge is going to be, Marshall Bucket, what his challenge is going to be is overcoming the standing issue. It's just not easy for an individual to come on behalf of everybody. The courts would be so tied up if you could bring a lawsuit when you haven't been injured. And remember, and really, not only am I not being injured by what's going on, although I could claim in some ways that I am. My pharmacies, my businesses benefit from the chaos that is happening out in the real world. The worse it gets out there, the more I get phone calls as to, can I do this and can I do that? I get busier the more chaotic the things are out there. So for me, it's especially difficult for me to claim I've been injured personally, and so I have the right to bother the judges with this issue. I'm not. I'm suggesting the citizens are being harmed by this, and the judges need to consider the extent to which the harm is happening enough to give a standing. The people have to retain the right to have these sort of issues heard. If the judges only allow public standing for issues that affect the judiciary. And as a layperson, when I read the Sheward case, and that's what the Court of Appeals is citing as to why they're not giving me standard, because it's a rare and extraordinary that somebody gets public standing, rare and extraordinary, and hasn't been given in 15 years. Well, as a layperson, I read through Sheward a couple of times, and I walked away thinking, well, you're only going to give public standing if the judiciary is. Public standing is public right. This is a public issue. It may not be a judiciary issue, but this is a public issue, and the judges are allowed enough discretion in deciding what they feel rises to the level of importance that they'll give public standing to. And if you could think it is conceivable for them not to ever give public standing to somebody bringing a public issue again. And that's possible. But if they agitate the public enough, I believe, and they're not sensitive enough to what is injurious to the public always retains the right to totally rearrange the judiciary or vote in or vote out judges that they want or people that are responsible if it, theoretically speaking. So I don't think they could strip the public of the right of obtaining public standing to that level that maybe the public wouldn't have the recourse to go back and change the very judiciary system that is the only thing that they're allowing public standing to try to protect. I don't know, but don't forget how the timing is going to play out with respect to the governor's race and whether or not DeWine or whoever would comment as to whether or not this is of public importance enough to at least hear the conversation. But if DeWine and his assistant attorney generals and this and that motion to dismiss it again, that it shouldn't even be heard, then that's where hopefully the public is engaged enough in the conversation that there might be some risk of some blowback from that, just enough to protect our rights to bring something like this forward.